Hello, I'm attorney Corey Ludeman with RSH Legal. If you've applied for Social Security disability benefits and been denied, you may believe you need to file a new application to get your case reviewed. However, that is not always the best plan of action. There are a few instances when restarting your Social Security disability claim is practical. Here are a few examples when it may make sense for you to start over with a new application. Option 1. You were declared disabled according to the Social Security Administration's rules but had too much income or too many assets. If your financial situation has gotten worse, for example, you're no longer able to work and you have less than $2,000 in assets if you're single, it may be a good idea to reapply for supplemental security income. If the denial was within 12 months of when you are reapplying, they should be able to reopen the old application. 2. If you have been working steadily, you may have accumulated more work credits. If you have enough work credits and are considered disabled by the SSA, you could qualify for Social Security Disability Insurance Benefits, SSDI. To know if you have enough work credits to meet the SSA's requirement, review your Social Security statement at ssa.gov/myaccount. 3. If you missed the 60-day window to appeal your denied claim, generally speaking, you only have 60 days to appeal your claim before you must refile your application. However, you may be able to get an extension of this deadline for good cause, so talk to a disability attorney to review your options. Now, restarting your disability claim isn't always a good idea. If your initial application has been denied, it's often better to go through the appeals process rather than starting over. The reason for this has to do with how your back pay is calculated. For SSI benefits, the date you file your application is the date used by the SSA to determine how much back pay that you are owed. Back pay, or past due benefits, is awarded for the months you had to wait to be approved. For SSD, the SSA can look back up to 17 months from when you filed the application to determine if you were disabled before you actually filed your claim. If you restart your application with a new file date, you could potentially lose out in thousands of dollars of back pay. If your condition has gotten worse or your limitations have increased, you do not need to restart your claim if you are still within the 60 days of the denial. An attorney can help gather your recent medical records and doctor's opinions and present them to the SSA for review. Depending upon where your claim is in the appeals process, these records will be reviewed by an administrative law judge or an SSA employee. Remember, just because your initial application was denied does not mean that you aren't entitled to benefits. An experienced Social Security disability attorney can help you navigate the appeals process and increase the odds of winning your case. If you'd like to know more about the Social Security disability process, you can download a free copy of our law guide to Iowa Social Security disability claims on our website, fightingforfairness.com.